Law Talk with Nick Maruchak. Thanks to MKI Legal, your trusted employment and family lawyers.
G'day, Nick.
G'day, Bowie.
Good to see you.
Likewise.
Busy out there?
Yep, very busy.
All right. Working late at night, working on weekends?
Yeah, and I'm also part of a startup. I'm doing a legal AI startup, so I'm part of the +8 program, which is sponsored by the state government. So I'm also doing that. So it's a great thing. So trying to help lawyers become more efficient with AI.
Yeah, it's everywhere, isn't it? I've always sort of tried to hold it at bay because we like to think the spoken word and the and live commentary, etc., is important, but it's everywhere.
Oh, it's a matter of time before it just infiltrates. It becomes part of your entire life.
Hopefully, we still need for humans, Nick, like yourself and me, and James and Anne and Sean. If you want to speak to Nick Maruchak, you can 133 882. We've had a text, and you might be able to address this for me. G'day, Jono. He says, why are those kids that were doing the racing not named and shamed? Their faces plastered all over the news and newspapers, so they're shamed in public. Thank you, Jono. Nick, we can't do that. We can't name minors.
You can name people over 18, but in WA there is, and probably everywhere around the country, there are strict laws prohibiting identifying individuals under 18 involved in any criminal proceedings. So you can't get their name, their face, their school, anything that can identify them. So that's against the law. And another point to note is we have the Young Offenders Act, which provides a mechanism to wipe the criminal record if after they turn 18 and after there's a period of like a 2-year period of good behaviour. So that there is a mechanism. So generally you kind of get a fresh start after 18 as long as you are good and when you do a criminal search it doesn't show. So there is that. I mean, there's a whole policy ground for that, which is, kids under 18 aren't adults. They don't have as much criminal responsibility as over 18. But as we know, as soon as you turn 18, your face can be plastered all over the news. And, that's how it works.
That's how it works. Thanks, Jono. Thanks for your thoughts. We do need to be careful in talking about court cases on social media. This was in the rumour file this morning. Have a listen.
From Legal Eagle. Oh, I have to read this as it's written, okay?
What, for legal reasons?
I do. A rumour has it that a popular Perth-based mummy blogger has received a very stern email from an interstate court after speculating about a well-known trial that is currently taking place and opening it up for comments to her followers. As we know, there are serious contempt of court issues in doing this with the trial currently taking place. And the court was quick to jump on the post, getting the blogger to delete it just under an hour after it was posted, by which then it had already had hundreds of comments on it. The blogger then posted again, explaining that she had to delete the post, but again, didn't turn comments off, so it all started again. Comments have now been turned off. Don't say anything further about that.
All right, so they've been published, haven't they, Nick?
Yes.
By definition?
Yep, that's right. So basically this area of law is something, it's contempt of court, right? So there's this special kind of word called sub judice contempt, and it's basically this right that prohibits publishing material that poses a real and definitive risk of prejudicing a trial, right? So you can't influence a trial. It's called the administration of justice. So what this really means is, and this applies to everyone, not just court reporters, right? You have to make sure that the trial is not unfairly influenced. And some of the things you have to really be careful of is not to reveal any information that the jury is not aware of, right? So sometimes an example is if the accused has a criminal record, that often is kept from the jury because that could influence their decision. So you can't reveal stuff like that. And you also have to really be careful when you're implying guilt or innocence of the accused as well, because that can influence things. So this is the right process the court has took, because as we know, social media, they have a long tail, which means that things are cached or kept on there, even though they're deleted, screenshots are shared, reshared. You can't get rid of something when it's on the internet, so it's good that they acted quick. And really the best course is just to stick to the objective facts that are reported, that the jury is aware of, right? Don't really go into territory of saying this person is guilty, etc. So,
All right. Yeah, once published, it remains published. You and I did talk about an issue last week where something had been published and could no longer be found, and that does create issues. But usually there's a screen capture or there's a way of finding publications that have since been deleted. 17 minutes to 9. If you'd like to phone Nick Maruchak, call through 1338 882 is the phone number today. Anything that you like. There has been. So I wanted to ask you about. There's sort of almost a burden of truth threshold in different procedures, Nick. So with regards to the fines enforcement, case with the Kimberley publican, the WA Supreme Court found the Liquor Commission misapplied the law in a police-backed complaint, and has now wiped hefty penalty against 2 Derby pubs, raising questions about procedural fairness in licensing enforcement. So there are different, and I'm using the term burdens of proof, which is my phrase, and it's probably not a real legal term. But in different jurisdictions, that the burden of being able to prove something to be fair or unfair or legal or illegal can differ a bit, can't it?
That's right. So when it's criminal cases, you have to prove beyond reasonable doubt. So there can be no doubt, and this is a much higher burden. In civil cases, such as this penalty hearing, it's on balance of probability. But this is basically a win for the pub, right? The police really went hard at this person and for a breach of I think it was like a packaged liquor restrictions, something like that, right? So there was a breach. They got this big fine of $140,000, right? But the key in this case was one of the people in the commission, one of the decision makers, wasn't present for the hearing. And so one of the judges wasn't even present at the hearing and still was involved in making the decision. So I don't know how that kind of got through. So, and then the Supreme Court said you can't do that. That denies the principle of natural justice, right? So whenever there's governments involved and administrations, you have to have the opportunity to be heard, and all the decision makers have to hear your case. So that was one that failed. And the other thing is, when it comes to this penalty, they really questioned whether the penalty was proportionate, right? So it was probably a bit too high. So they sent it back to the Liquor Commission tribunal, and hopefully it gets reassessed and reevaluated there. But it's good to see the pub win. But they probably spent a bunch on legal fees to kind of go through this whole fight, and it would have been quite an ordeal for them. Yeah, for sure. 1338 882 if you'd like to speak to Nick Maruchak today. Nick, we will take a break. It's 14 minutes to 11. If you have any legal questions, family law questions, deceased estates, anything like that, give Nick Maruchak a call from MKI Legal. 14 minutes to 11. If you have a query for Nick Maruchak from MKI Legal, give us a bell, 1338 882. Rose has phoned in. G'day, Rose.
Hi, how you going?
Good, thank you.
I have a question about filling out forms for the e-portal for the court system. So I have to get a statement from a witness. So do I get him to Form 32A or something? Do I get him to fill that out, and can he type that, or does he have to handwrite it?
Okay, so you're going through a civil claim, it sounds like it, Rose.
Claim.
Yep, in the magistrate's court. Yep, Form 32A, statement of intended evidence of a witness. So it's basically like a witness statement. So you could, he could type it out, right? And it's basically his version in first person. So this witness will just say, this is what I heard, this is what I saw. Sometimes we do these all the time as lawyers. We'll sit down with a witness, get their evidence, and then type it out. So, and the other thing is, this is probably a side note, that the software I mentioned that I was creating, it's actually for witness statements. So my AI software can record a meeting with the witness and it can create the witness statement for you. So Rose, if you want help, because a lot of lawyers actually don't want to use it because it makes them more efficient. So if you want to use it, Rose, you can use our software. You can record the meeting with this witness, and you can get an AI to produce the witness statement for you, and then you have to tidy it up. And check it, of course. But if you like to use it, I can help you. It took me about 3 months to create it, or 2 months. And it's working really great. So if that might help as well.
Do I then have to take that to the court and they stamp it, and then I have to give it to the other party?
You upload it. You upload it to the court portal. So a lot of these filings are done online. you'll have a due date to do that. So you upload it, the court will process it, and then you send it off to the other side as well, right, before the deadline in the court orders.
So they then send it back to me, stamped.
Yeah, when you file it in the court portal, they'll have to process it, and then I haven't done it for a long time, but you download it, and they'll give you there's a court seal on the electronic copy, and then you send it to them on the other side. Yeah, so it's all done online these days. And if you're having real trouble online, that they do have exceptions. So, yeah, that's how you do it.
Does that help out, Rose?
Sort of, because the other person's got like 4 witnesses and I've only got 1 document given to me. And
yeah, I mean, look, if your witness on your side is not cooperating and doesn't want to provide a statement, then you can subpoena them as well. And that's where you would fill out this Form 32A with your best kind of evidence that you believe.
Okay, I think I've got it. Okay, thanks very much for your help.
No worries.
No, stay in touch, Rose. If we can help, or if Nick can help, he will. Thank you for your call. G'day, Phil.
Yes, g'day. I had a real estate agent managing a commercial property for me. At the end of the lease, the tenant owed a lot of back rent and interest on the back rent that wasn't paid or was paid. And then at the end, the agent never pursued to recover the money. So I actually took the tenant to court and recovered the money through the magistrate's court. But then the tenant wouldn't pay the money back to me directly. They paid it to the real estate agent. And the real estate agent took his commission out of it, even though he did nothing. Is he entitled to that?
This is a good question. So that you want to have a look at his terms of engagement first, right? So I would imagine his terms of engagement are pretty broad that would entitle him to the commission received. You want to see if there's a term in the contract that forces him to go and pursue the claim on your behalf in the magistrate's court. So check the contract first. The other thing is there is law that says if an unfair contract term, right, if a term in a consumer contract is unfair, that can be challenged. So on the face of it, I think that there's probably an argument that if, he's getting commission unfairly here, so the unfair contract terms could apply. It's not clear cut. So you could write to him and say, look, I think it's unfair that you're receiving this, unfair contract terms, give me my money back. And if he doesn't, you can threaten to go to the magistrate's court. And if your claim's under 10,000, win or lose, you're not going to pay the legal costs. So that's something to try and recover as much as you can. The other thing is Department of Commerce regulates this industry. So just check with them to see if there's any procedures that real estate agents have to follow in these circumstances, and just to see if there's been any rules that have been breached here as well. So they're the 2 courses you can try.
Okay, thank you.
Thanks, Phil. Good on you, mate. This is a text from Katie. Thanks, Katie. A family member works at a daycare. Imagine they started a contract when starting. They can't work at another daycare centre within 50 kilometres if they leave. The place she's employed at the moment continues to hang promotion pay rises over them, but without actually ever going through with it. At face value, is this actually enforceable?
Great question. So this is called restraint of trade, right? In employment contracts, sometimes there's clauses that say after you leave, you can't work for a competitor. Now, the way these clauses work is on the face of it, they are unenforceable. So their starting position in WA is they're not enforceable unless the employer proves that they are reasonable. So this is the grey area, right? So sometimes they're reasonable in certain circumstances. In this case, I'm looking at this on the face of it, and 50 kilometres sounds
It's the whole metro area.
Yeah, this is just my initial view on it. This one will be hard to enforce. So I don't think this one would be unless the person is really senior up or something like that. If they're working just in a regular job, then no, I don't think the court will probably enforce this one. And what normally happens is if the employer really wants to go after you, they usually write to you first. Then you can try and negotiate with them. But look, I have to also give you the worst case. Worst case is if I'm wrong and I don't look. This one sounds like it's not going to stand up. But say if it does stand up, then that you go through the court process, you go through legal fees. It's a big nightmare. But most of the time,
it sounds like restraint of trade, doesn't it?
Yeah, and so most of the time that employers don't really go after you for this unless you're causing them monetary loss, right? So if you're causing financial loss, then they might go after you, or if you're really senior, they'll go after you, or if they hate you, they'll go after you. But in this case, I would probably push back and say, no, look, this one is it's too wide, right? So too wide, and if it's too wide, then it's not enforceable. So.
Yeah, there you go, Katie. I hope that helped, Katie. Yeah, I think that sometimes, and again, it depends on the person and the relationship with the organisation. In the media, sometimes you're not allowed to work for another media outlet for 6 months or 12 months or whatever it is, like a sunset clause, but it's not always applied.
That's right.
And it varies.
And there is laws that have been discussed that are potentially going through Parliament to eliminate these clauses for people under the high income threshold. So if you're under like 175K, they want to try and reduce these laws from applying. So that's laws that are being currently considered, and the government wrote a report on it, and they reckon they'll add heaps of economic value and productivity to it. And they're really prevalent in certain industries like IT, hairdressing. They're misused.
Yep. Let me put you under the spot a little bit, Nick Maruchak. We are asking the question today of our listeners. You're a lawyer. Are you concerned about sentencing in the community being too lenient, given that the young fellow involved in the tragic death of Nick Campo a couple of years ago got 3 years and 2 months? Our listeners are saying yes, 54s, no's 9. Are you a no?
I am concerned that it's too lenient. That's my personal opinion, right? I think this...
You're a yes.
Yeah, so I'm a yes, because I think, this driver, he was old enough to drive. I mean, sure, he's under 18, but he's over 18 now. But he was old enough to know right and wrong. So I think his sentence should be... I'm a yes.
Tougher.
Yeah,
all right.
think so.
Thank you for this week, Nick. I'll look forward. And thanks for helping out our listeners, and especially Rose with the offer of the AI transcription service. Like it. Good idea. Hope it goes well for you, mate.
Thank you.
Give a little lever cuddle for us.
Will do.
And we'll see you next week.
Thank you, Bowie.
See you, mate. Nick Maruchak back next week. Lucky to have him. 3.5 to 11. Mick Collis will join us soon.